So that's really, I think, the core spin in terms of the evidence and in terms of the expectations of the courts with undue influence. But the last point I was going to say in terms of the process here, and these are, as we talk about these legal issues, and we're going to move on to some of the other ones briefly after this, is that really, typically in an estate challenge, will challenge, you're going to look to lack of testamentary capacity, and you're going to look to undue influence. And at the outset, almost always, you're going to allege both, or both are going to be alleged against you. But the trick is, and the strategy is when do you let go? And do you let go of, and we talked about it for cost consequences, but with undue influence, you want to, I tell our clients we have to monitor that issue on a regular basis, because there's always the chance if you let go, you're not going to get stung like a bee by having alleged it. Because it's not such a terrible thing to suggest, because it's one of the 4 or 5 cornerstone issues in a will challenge.
And I guess, Ian, just in terms of winding up, just one thing I think we should make mention of the fact is that even though there are these traditional 5 grounds of challenging a will, not all 5 have to be present in every case, and in most cases they're not. And you may just have a will challenge based simply on undue influence, or simply on lack of testamentary capacity, or a will not having been properly executed. So these are not things that have to be found all together. They're mutually exclusive. They can, however, be joined in a claim for a challenge to a will.
So if we're ready, from a strategy standpoint, we want to maybe put 1, 2, 3, or 4 out on the table, but also be mindful of the fact that, while you may have the right to investigate those circumstances, you may not want to hang on to that allegation forever. So I think from that standpoint, before we cover off one of the last issues, and that is the question of lack of due execution, and then some of the corporate machinations in the corporate context of how these will challenges go. I just want to say that my last comment is on the question of fraud. As we said before, it really is not worthy of a ton of discussion. It's just not typically alleged. But in our next podcast, we'll start with that issue, just because of the one rare occasion when it's alleged, it can be dealt with on a very fairly pinpointed and sophisticated basis, which we're going to talk a little bit in our next podcast, and that's when we have forged wills. So thank you very much, Suzana.
Thanks to you too, Ian, and to all of you who are listening and watching us by video podcast. A quick reminder that if you have any comments and you'd like to share them with us, we certainly appreciate them. Feel free to call us at 206-457-1985. And of course, email at hullandhull@gmail.com. Thanks, Ian.
You've been listening to Hull on Estate and Succession Planning with Ian Hull and Suzana Popovic-Montag. The podcast you've been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other Hull On podcasts or to leave any questions or comments, please visit our website at hullestatemediation.com.